safety in clinical or in industrial workplaces, for example, in hospitals. For the second one, the working time and schedules, typical examples include the Saturday Sabbath observed by the Seventh Adventist Day believers, and also the Muslim prayers break or the judgments required during Ramadan. And all this creates some problems in terms of working time and schedules. The Portuguese Constitutional Court case law has played a particular important role here, especially where rigid scheduling rules unduly affect minority religious practices. For the third one, the food practices, here we have some problems related to canteen services to offer options compliant with religious dietary requirements. As you know, some religions, they cannot eat pork, not eat some food, be vegetarian, and in certain professions there's also a problem. Issues also arise when workers refuse to handle goods prohibited by their faith. For example, when you work in a supermarket, for example, sometimes could be an employee that refuses to handle, for example, some pork meat. And the last one about the proselytism, while freedom of expression applies to all workers, it's true, attempts to convert colleagues during working hours, so have some conversations about religion. Or in the case of domestic workers, there's very serious problems when the employer, the domestic employee, try to influence the religious views of the children at home. And this may breach duties of professionalism and respect. The next. And just a few words about the legal framework. In fact, freedom of religion and the prohibition of discrimination, the prohibition of discrimination in these religious grounds are protected in international human rights treaties and in the constitutional traditions of the democratic states. We all know that. And the key point is that religious freedom includes two different areas. Includes the forum internum, that is the internal freedom to believe, and also the forum externum, that it's the freedom to manifest those beliefs. And the problem is related to the second one, this freedom to manifest those beliefs, because most of the legal problems arise when the employee wants to manifest some of his beliefs, to the external manifestation of religion, in fact, which is precisely where workplace regulations interact with personal beliefs. Because the employment relationship is built on this idea of subordination, the employee is in a position of subordination, employers do have legitimate powers to organize the work, to organize the company. But this power, in fact, is not unlimited, because any restriction on religious freedom must be justified, necessary, and proportionate. And European courts in this matter have insisted on this principle, that restrictions cannot rely on vague or inconsistent claims about corporate image of the company. That's not the justification to limit the freedom of religion. They must reflect genuine needs such as neutrality of public administration, health, safety, or the rights of others. About the European case law, I have here, I need to make the, to underline the case law of the European Court of Human Rights and the Court of Justice of the European Union. About the Court of the European Court of Human Rights, cases, we can have some cases involving teachers, nurses, airline staff, and many others that illustrate the balancing exercise between equality, neutrality, and individual freedom. And the court has upheld restrictions when necessary for safety or public sector neutrality. But it has also condemned arbitrary bans, such as prohibiting a visible crucifix while allowing other religious symbols. And we have a case law about this topic. The Court of Justice for the European Union has recognized that the workplace neutrality policies can amount to indirect discrimination if they disproportionately affect certain religious groups, particularly the Muslim women wearing the hijab. And the court has also stated that employers should consider alternative arrangements, such as relocating employees to non-customers facing roles, to some backstage work. This approach brings us closer to a very important concept in this area, in my opinion, that it's the idea of reasonable accommodation. And what is this? The reasonable accommodation that in my opinion, is the key to solve this kind of problems. In fact, in Europe, the concept of reasonable accommodation for religion remains underdeveloped. Traditionally, this is only applied mainly in the context of disability rights. In Europe, we use that concept, in fact, for the disability rights, for disability person. However, experiences from Canada and from the United States show that reasonable accommodation is a powerful tool to combat indirect discrimination. That it's situations where apparently neutral rules impose disproportionate burden in certain religious groups. And reasonable accommodation requires employers to take modest practical steps to adapt work conditions, unless doing so could impose an undue hardship. What in practical terms is this reasonable accommodation? Some examples include, for example, modify schedules when possible, allowing religious symbols unless safety demands otherwise, offering short prayer breaks, or, for example, providing alternative meal options, adapting tasks when certain activities conflict with religious prohibitions, and you have here some examples of reasonable accommodation. In fact, in Portugal, we have an Article 14 of the freedom of religion law, that it's a very well-known law all over the world, because it's considered a very, very good law in terms of freedom of religions. And this law contains a limited provision for exemptions from work for religious reasons. And the Portuguese Constitutional Court has recently highlighted the need to understand this provision in line with the principles of tolerance, equality, and maximum effectiveness of fundamental rights. But there is still much space for growth in fully recognizing this idea of accommodation as a general principle for religious diversity in work. Let me conclude just with 3 ideas. The first one is that religious diversity is a structural reality of contemporary workplaces. And it is neither a normal nor a temporary phenomenon, and it is part of who we are as a society. The second idea is that employees do not surrender their religious identity when they sign an employment contract. Freedom of religion includes the right to manifest beliefs, not only to hold them in our internal ideas. And the third one, the most effective way to settle religious pluralism with organizational interests is through this idea of reasonable accommodation. And it allows flexibility, prevents discrimination, and could reduce litigation and supports this idea of social cohesion, that it's very important nowadays to keep this idea of tolerance among all citizens. Promoting this religious diversity in the workplace is not only a matter of respecting fundamental rights, it's also an opportunity for organizations to cultivate more inclusive, more tolerant, and more resilient environments of workplace. Thank you for your attention, and we could discuss